Hello, welcome back to labor relations. So, we have previously discussed Title 1, Title 4, and Title 5 of the labor relations. Now, let us proceed to Title 6 about unfair labor practices. So, unfair labor practices is composed of three chapters. Chapter 1 is the concept. Chapter 2 is the unfair labor practices of employers, and Chapter 3 is the unfair labor practices of labor organizations. So therefore, it is it is not only the employers who commit unfair labor practices, but also the labor organizations. So now let us proceed to the discussion proper. So first is the concept of unfair labor practices, or ULP in short. Now, um, why are unfair labor practices prohibited under our jurisdiction? So these are among the reasons why um, unfair labor practices are prohibited under our jurisdiction. So they violate the constitutional right of workers and employees to self-organization. They are inimical to the legitimate interest of both labor and management, including their right to bargain collectively and otherwise deal with each other in an atmosphere of freedom and mutual respect. They disrupt industrial peace and they hinder the promotion of healthy and stable labor management relations. So, again, these are among the reasons why unfair labor practices are prohibited under our jurisdiction. Now, an unfair labor practice, a, or a person who commits an unfair labor practice is not only civilly liable for such, but also criminally liable because the unfair labor practices has two aspects. Okay, they are violations of the civil rights of both labor and management, and are also considered as criminal offenses against the state. Okay, so hindi lang liable for the civil liability ang person na nag-commit ng unfair labor practice, but also criminally liable because the commission of an unfair labor practice is considered a crime. Now, who has jurisdiction over unfair labor practice? So, under the code, it is the labor arbiter who has jurisdiction over the unfair labor practices for the civil aspect, while it is the regular courts which has jurisdiction with respect to the criminal aspect of the unfair labor practice. So if ang kailangan lang singilin is yung money, yung damages, okay, yung civil liability, sa labor practice, sa labor arbiter, siya dapat i-file ang case. Pero kung i-prosecute talaga yung person na nag-commit ng unfair labor practice, kakasuhan siya ng criminal charge, then dapat sa regular court i-file ang case. Okay, so that is the concept. That is for the concept. Now let us proceed to the chapter 2, the unfair labor practices committed by the employers. So first is the interference, that is to interfere with, restrain, or coerce employees in the exercise of their right to self-organization. So the employer has no business meddling with the or how the employee should handle his or her right to self-organization. So, walang right yung employer na meddle dun sa kung ano man gustong gawin ng employee with respect to his or her right to self-organization. So if the employer interferes or restrain or coerce the employees in the exercise of their right to self-organization, it would be considered as an unfair labor practice. Second ULP is the yellow dog condition. This is to require as a condition of employment that a person or an employee shall not join a labor organization or shall withdraw from one to which he belongs. So uh, this just means that the employer is requiring the employee not to join a labor organization. Otherwise, if the employee joins a labor organization, he would be um, uh, effectively dismissed from his employment. So these are the typical stipulations of a yellow dog contract. A representation by the employee that he is not a member of a labor organization. A promise by the employee that he will not join a union, and a promise by the employee that upon joining a labor organization, he will quit his employment. So those are some examples of a yellow dog condition. Next is contracting out. That is to contract out services or functions being performed by union members when such will interfere with, restrain, or coerce employees in the exercise of their right to self-organization. So the employer outsources the work that normally should have been done by the employees of the employer. Okay, so uh, let's just be clear here that outsourcing per se is not an unfair labor practice. Okay, outsourcing is the business practice of hiring a party outside of a company to perform services and create goods that traditionally were performed in-house by the company's own employees and staff. Outsourcing or contracting out is not per se an unfair labor practice. Okay, it would only become an unfair labor practice if such outsourcing or contracting out will interfere with, restrain, or coerce employees in the exercise of the right to self-organization. So if it has the intention of the employer is coupled with anti-unionism, okay, the employer outsourced the work of his or her employees in order to go against the activities of the unions of his or her employees, then that would become an unfair labor practice. Okay. So a basic example of this outsourcing or contracting out, which constitutes an unfair labor practice, is this runaway shop. Okay, it is an industrial plant moved by its owners from one location to another to escape union labor regulations or state laws, or a plant removed to a new location in order to discriminate against employees at the old plant because of their union activities, or to a business relocation animated by anti-union animus rather than for business reasons. So the reason behind why the job or the work is outsourced is not really legitimate. It's not for business reasons, but for anti-union reasons. Okay, it has, the employer has an intent to go against or to interfere with the union activities of the employees. Next is company unionism or company domination of union. Now, that is to initiate, dominate, assist, or otherwise interfere with the formation or administration of any labor organization including the giving of financial or other support to it or its organizers or supporters. So, di ba, the essence of a labor organization is so that the employees cannot be easily um, be defeated by the employer. Okay, so but if this labor organization is controlled by uh, the employer, then that purpose of the labor organization would be defeated. Okay, so a labor union is company dominated where it appears that key officials of the company have been forcing employees belonging to a rival labor union to join the former under pain of dismissal should they refuse to do so. That key officials of the company as well as its legal counsel have attended the election of officers of the former union, that officers and members of the rival union were dismissed allegedly pursuant to a retrenchment policy of the company after they had presented demands for the improvement of the working conditions despite its alleged retrenchment policy, and that after dismissal of the aforesaid officers of the rival union, the company engages the services of new laborers. So those are examples where there is company unionism in the conduct of the employer. Next, ULP is discrimination for or against union membership. Now, this is to discriminate in regard to wages, hours of work, and other terms and conditions of employment in order to encourage or discourage membership in any labor organization. Okay, so what the law prohibits here is discrimination to encourage or discourage membership in a labor organization, where the purpose is to influence the union activity of employees. The discrimination is unlawful. Okay, so however, discrimination is not the same as differentiation or classification. Okay, so for instance, it is common management practice to classify jobs and grant them varying levels of pay or benefits package. These are valid differentiations that recognize differences in job requirements or contributions. They are not necessarily discrimination classifiable as unfair labor practice. Now, while the law uh, or the labor code prohibits discrimination for or against union membership, uh, nothing in the labor code or any other law shall stop the parties from requiring membership in a recognized collective bargaining agent as a condition for employment, except those employees who are already members of another union at the time of the signing of the collective bargaining agreement. So this compulsory membership in the recognized collective bargaining agent as a condition for the continued employment is called the union security clause. Okay, so it just basically means that um, the employees are required, okay, to join a specific labor organization which is a collective bargaining agent. Okay, and those who refuses to join um, the labor organization which is the collective bargaining agent may be dismissed from employment. Okay, so that is the essence of the union security clause. However, those employees who are already members of another labor organization at the time of the signing of the collective bargaining agreement cannot be compelled to join that labor organization which is the collective bargaining agent. Okay, so pwede yun na i-require ang mga employees na dapat sila mag-join sa isang labor organization na collective bargaining agent. Otherwise, kung hindi sila mag-join, they can be dismissed from employment. So that is union security clause. So next is the discrimination because of testimony or retaliation by the employer. That is to dismiss, discharge, or otherwise prejudice or discriminate against an employee for having given or being about to give testimony under the labor code. Okay, so the law protects not only the employee's right to form, join, or assist a labor organizations, but also the right to testify on matters covered by the labor code. Okay, so if this right is not protected, the right to self-organization will be indirectly defeated because the employees will fear their employer's reprisal. So by protecting the employee's right to testify, the labor code therefore shields the worker's right to self-organization from indirect assault by the employer. Thus, it is unfair labor practice to dismiss, discharge, or otherwise prejudice or discriminate against an employee for having given or being about to give testimony under the labor code. The next ULP is the violation of the duty to bargain. That is to violate the duty to bargain collectively as prescribed by the labor code. Now, so what is this duty to bargain collectively? So we will discuss this in the next title. Basta, just for now, remember that the violation of that duty to bargain collectively is considered an unfair labor practice. So next is the paid negotiation. Okay, so that is to pay negotiation or attorney's fees to the union or its officers or agents as part of the settlement of any issue in collective bargaining or any other dispute. Okay, so because self-organization and collective bargaining are treasured rights of the workers. Okay, so therefore the law um, shields these rights from corruption. Okay, so it is a punishable act of unfair labor practice for the employer to pay the union or any of its officers or agents any negotiation fee or attorney's fee as part of settlement in collective bargaining or any labor dispute. Okay, so to do so is not only unlawful, it is ethically reprehensible. So next is the violation of the collective bargaining agreement or CBA. That is, okay, so it is an unfair labor practice to violate a collective bargaining agreement. Okay, so after a CBA is concluded, its implementation follows. Now, implementation is still part of the bargaining process which rests on the parties' duty to bargain. And then the duty to bargain requires good faith, and good faith implies faithful observance of what has been agreed upon in the collective bargaining agreement. So it follows that non-compliance with the agreement is non-observance in good faith of the bargaining, and therefore that non-compliance is considered as an unfair labor practice. But, okay, take note, the violation of the collective bargaining agreement must be gross as required by the labor code. So who are those persons criminally liable for unfair labor practices committed by the employers? So of course, if the employer is only one single proprietorship ang business or establishment, then it is the owner, the sole proprietor of the establishment or the sole owner of the establishment who is criminally liable for the unfair labor practice. But if uh, the employer is a corporation, association, or partnership, okay, the persons criminally liable for the unfair labor practice are those officers, agents, I mean officers and agents who have actually participated in, authorized, or ratified the unfair labor practice. So, sino talaga yung may mga officers or agents na may kinalaman or direct participation in the commission of the unfair labor practice? Okay, sila yung criminally liable. Okay, so now let us proceed to chapter 3, the unfair labor practices of labor organizations. Like what I have said, uh, it is not only the employers who commit unfair labor practice. Also, labor organizations may commit unfair labor practices. So for the first ULP, or unfair labor practice of a labor organization, is a restraint or coercion by the labor organization. That is to restrain or coerce employees in the exercise of their right to self-organization. Okay, so is as if you could remember or analyze under the unfair labor practices of the employers. Okay, meron aside from the restraint and coercion, meron doon na interference. Okay, ang employer bawal mag-interfere, restrain, or coerce. But here in labor organizations, ang bawal lang sa kanila is to restrain or coerce employees in the exercise of their right to self-organization. So, meaning, pwede sila mag-interfere into the rights, into the, the exercise of the right to self-organization of the employees. Okay, so interference by a labor organization is not considered as a unfair labor practice. Okay, so a labor organization may interfere in the employee's right to self-organization as long as the interference does not amount to restraint or coercion. Okay, but we must take note, however, that a labor organization shall have the right to prescribe its own rules with respect to the acquisition or retention of membership. So, may right si labor organization kung sino ba ang pwede mag-join or sino ba ang members nila. Okay, so may right ang labor organization to identify kung sino lang na employees ang pwede nilang maging members. Okay, so that would be the general rule. Okay, that the labor organization has the right to select or to screen who should be members of the labor organization. However, if there is a closed shop or similar agreement, may union security clause, then qualified applicants may not be arbitrarily excluded from membership and their admission may not be barred by unreasonable rules. Why? Kasi nga, kung may union security clause, pwede na ma-expel or ma-dismiss from the employment yung employee if they are not member or they are not a member of the labor organization, which is the collective bargaining agreement. Okay, so hindi pwede na na i-reject sila ng labor organization kung may union security clause. Okay, so the next ULP committed by that may be committed by the labor organization is the union-induced discrimination, that is to cause or attempt to cause an employer to discriminate against an employee, including discrimination against an employee with respect to whom membership in such organization has been denied, or to terminate an employee on any ground other than the usual terms and conditions under which membership or continuation of membership is made available to other members. Okay, so the labor code forbids as an unfair labor practice union attempts to cause an employer to grant advantages for union members over non-members, okay, for union members in good standing over suspended or expelled members, for union members over permit holders, for members of the union executive board over more senior employees, and for members of one union over members of another union, or for members of one local over members of another local. Okay, so the forbidden discrimination may refer to the terms of hiring or firing, in layoff, in seniority, or in benefits. Next ULP that may be committed by labor organizations is the refusal to bargain. So that is to violate the duty or to refuse to bargain collectively with the employer, provided it is the representative of the employees. So this is the same with the refusal to bargain na ULP by the employer. Again, just remember that the refusal to bargain is ULP, and we will discuss what is this duty to bargain collectively in the next title. Next ULP is the feather bedding and make work arrangements. So that is to cause or attempt to cause an employer to pay or deliver or agree to pay or deliver any money or other things of value in the nature of an exaction for services which are not performed or not to be performed, including the demand for fee for union negotiations. So this feather bedding term is a term given to employee practices which create or spread employment by unnecessarily maintaining or increasing the number of employees used or the amount of the time consumed to work on a particular job. So most of these practices stem from a desire on the part of employees for job security in the face of technological improvements or in the face of employer subcontracting. In spite of employee assertions that this so-called feather bedding or make work arrangement practices are directly related to job security or health and safety, most courts at common law found these practices to be economically wasteful and without any legitimate employee justification. So next ULP is the collective bargaining agreement deal with the employer. That is to ask for or accept negotiation or attorney's fees from employers as part of the settlement of any issue in collective bargaining or any other dispute. Okay, so therefore, asking for or accepting some fee from the employer as part of CBA or dispute settlement is considered unfair labor practice by the union, um, and in fact, such act is more than just an unfair labor practice. It is a reprehensible betrayal of trust, an act that deserves condemnation of the highest order. Thus, under um, this act was listed as a ground for cancellation of union registration. So, as you can see, diba, in our previous discussion, that this kind of violation would be considered can be considered as a ground for cancellation of the registration of the labor organization. The last, uh, the same with the ULP committed by the employer is the violation of the CBA. Okay, again, the violation must be gross as required by the labor code. So now we are done with Title 6 regarding unfair labor practices. So on our next discussion, we will proceed with Title 7 regarding collective bargaining and administration of the agreements.